We have two questions that we're bringing to the Supreme Court that we have to get addressed. They're both rhetorical. We don't even need them answered, right? They already know the answer. That's why they're silent on it. The first question is, do states have the authority to substitute their own alternative legislation for the provisions that guarantees of the Constitution of the United States of America? No, states don't have authority to do that. Great, awesome. Now we can get rid of all these state statutes that are all unconstitutional, all these state constitutional provisions that are all unconstitutional, all these states that say we're sovereign, right? And get rid of all that bullshit from question number one. Question number two is, does the judicial branch have lawful or constitutional authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution of the United States of America? The answer is no. So now we can go to the judicial branch and remove all of this bullshit rulings that they put into place that's contrary, that amended or altered the Constitution of the United States based upon their legal realism and judicial fiat. We can go back and remove all that, place the Constitution back at its foundation, have it come as the overarching laws that go across the entire United States. And in doing so, we will then let the dust settle where it may. And if the Supreme Court of the United States made a ruling in 1833 that says that criminal defendants don't get the very guarantees that they're entitled to and written and enumerated in the Bill of Rights because we don't want to give it to them, as they did in Barron v. Baltimore, United States Supreme Court, then that fraud of court that was introduced, that fraud that the Supreme Court, the highest court in the land, introduced fraud, and that fraud is now permeated to every single court across the entire nation, which means that every single thing that all these courts do is going to be unconstitutional because it derives from this act, this ruling that was put into place by the Supreme Court of the United States that was clearly unconstitutional because they directed all of the courts within the purview of the Supreme Court that they don't have to follow the Constitution of the United States. That's what put us into martial law. A lot of people talk about martial law. Martial law derives from martial court. We have been in martial law ever since Barron v. Baltimore was put into place because no one in the history of our nation has ever been protected by all of the provisions and guarantees of the Constitution, because the Supreme Court of the United States, the highest court in the land, came out and made the statement or directed all the courts within its purview to not give the very rights that are guaranteed to the people of the United States in Barron v. Baltimore. And what happened there was that Marshall suspended statutory obligations, because the Constitution is nothing more than a statute that created obligations. So when they say that we can suspend statutory obligations, which is what martial law is, they suspend statutory obligations. And that's also what happened in the Emergency Powers Act, right? That allowed for COVID to be able to lock everything down, because the Emergency Powers Act says that the governors have the right to be able to suspend statutory obligations in certain emergency conditions. Well, that's an oxymoron, right? How can government suspend statutory obligation when the Constitution is a statutory obligation? So when you say that government can suspend statutory obligation, what you're saying is that the government can suspend the Constitution of the United States. That's what happened with COVID, right? That's what happened when the establishment of the Emergency Powers Act went into play. When you read the Emergency Powers Act, that's exactly what it states. It says that the governor can suspend statutory obligations, which means that the governor can suspend the law. Now, our founders and forefathers would have never created a document that guarantees rights and limits powers, but then in the same breath permit the very powers that are to be restrained to be able to be suspended at their will. That doesn't even make sense. Because if we created a law and a constitution that guarantees rights and limits powers, then how can those with power suspend the very power that restrains them? Doesn't even make sense. So martial law has no validity, but martial law was created by the martial court, right? And so that's where those words come into play as well.